First District Court of Appeal is now in session. All who have business before this court, draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case on our docket this morning. Case number 21-2114, Zachary Wester versus State of Florida. Mr. Efferman, when you're ready.
Good morning. May it please the court. Michael Efferman on behalf of the appellant, Zachary Wester. I'd like to reserve 5 minutes of my time for rebuttal. I intend to focus my time this morning on the first claim raised in the briefs, and that is whether the trial court erred by denying the motion for judgment of acquittal for the RICO count one in the information. Now, there's no factual dispute in this case. The facts are clearly established based on what was alleged in the information and what came out during the trial. This is purely a legal issue as to whether or not these facts amount to or satisfy the enterprise element, the criminal enterprise element of the RICO charge in this case. In my briefs, I've cited to a couple of federal cases regarding what's required for an enterprise. I've cited to the Nazar case from the Middle District of Florida in 2017, and there the federal courts explained that a RICO enterprise is a group of persons or associates that exist with the purpose of conducting illegal activity. I also cited to the Hughes case from the 11th Circuit for the same exact principle. And in the briefs also cite to the Gross case from the Florida Supreme Court in 2000. And in Gross, the Florida Supreme Court explained a couple things. Number one, they explained that the Florida RICO statute mirrors the federal RICO statute, and Florida courts therefore look to federal courts for determination regarding what's required for the elements of RICO. And the Florida Supreme Court in Gross was determining what is required for an enterprise. And specifically, the Florida Supreme Court held that to prove an enterprise, the state must establish two elements. One, an ongoing organization, either formal or informal, with a common purpose of engaging in a course of conduct, and two, which functions as a continuing unit. In this case, the state's evidence completely fails to establish enterprise, completely fails to establish that there was a common purpose. And I cited to, and I probably more than I should have.
So the prototypical example is the enterprise itself is illicit. So if the enterprise is licit and the statute defines enterprise in terms of you have illicit enterprises and you have licit enterprises, how does your argument work in the context of a licit enterprise?
So the best example would be a police department where there are multiple bad actors, multiple bad cops. Certainly we're aware of those cases in Florida. We're aware of them nationwide. Even in that context, you still have an association amongst the bad police officers to engage in some type of common purpose, which would be a criminal purpose. The Miami River cops from many years ago.
So there you're saying the enterprise is not the police department. The enterprise is
the association that's performed within that legal entity. Mm-hmm. So, and I think courts have struggled around the country. There's clearly...
Because the Ruiz case said the enterprise was the police department. There were a couple of bad law enforcement officers, but they said the enterprise here is the police department. And the officer's misconduct is the racketeering part of...
I think the courts discuss this idea of if you have a licit entity or a legal entity, do you have an association, in fact, underneath that licit entity where you would meet the common purpose requirement of enterprise. And again, I think every example that I've come across, and more importantly, I think every example that's been cited by the trial court below or been cited by the state, there's not a single case that involves a single actor and a legal entity where their purposes would be different. Now, you can have a legal entity such as a police department where people within that police department associate together with a common purpose of engaging in illegal conduct. You can have a single actor who forms an illegal company. There was a case years ago that I'm familiar that came up to this court involving a payday loan company, where the company was charging more than what Florida law allows for payday loans. The defendant is the one that created that company, that he was charged with RICO, and the enterprise was the company that he created. He was the defendant named in the information, but the common purpose was that both the company that he created and the defendant had the purpose of violating Florida law, charging Floridians with more than what Florida law allowed for a payday loan.
Well, let's take the Jackson case, for example, and I like the phrase dropped in that case, one-man band. I thought that was on point, where, you know, he acted alone with respect to the illegal activity, but used the various corporations and the people working there to carry that out. So here, there's no question that the sheriff's office was utilized. You had custodians of evidence, you had the people who jailed the victims, et cetera, and so forth. So are you saying that that we should interpret the statute to mean that more than one person must be a voluntary participant in the illegal activity?
Yes, because again, there must be a common purpose. So again, I'm only aware, and the state hasn't cited to, and the trial court was asking for and couldn't find one himself. There's not a single case out there where you have a single actor and a legal entity where their purposes would be different. There are cases where you have legal entities where people associate underneath that legal entity, create an association, in fact, and have an illegal purpose. And again, the example I was just giving, there's cases where you can have a single actor and an illegal entity, and they associate for the common purpose of illegal activity. But in this case, if the requirement from Gross is that there must be a common purpose, the state hasn't ever responded or explained what that common purpose would be. The purpose, and the prosecutor below was very candid with the court, and he acknowledged that, yes, he was alleging that the Jackson County Sheriff's Office was the enterprise, but he acknowledged that the Jackson County Sheriff's Office purpose is to protect the public. The state's allegations against my client are that his purpose was to frame the public, to plant drugs on the public. There's simply no common purpose. So Gross has specifically said.
Now, the statute doesn't talk about common purpose, right? The statute, the emphasis in the statute on what the prohibited activities are, focus on the person. It is unlawful for any person employed by an enterprise. So it's not that the enterprise needs to be illicit or there needs to be some illicit enterprise. It's that a person is is engaging in the enterprise through a pattern of racketeering activity. So it seems more that the bare statute itself is talking about a person who's associated and maybe using the badges of the enterprise to do bad things, but the focus, again, seems to be any person and not bad enterprise.
I acknowledge that the common purpose language does not exist in the statute. It also doesn't exist in the standard jury instruction. Now, there are some pattern jury instructions throughout the country that do talk about the common purpose and always then talk about that purpose being an illegal purpose, consistent with the Nazir and Hughes case that I cited in federal court. But again, you have federal court, the federal court cases, and these aren't just two. There's hundreds of cases that state this exact principle, that a RICO enterprise exists where a group of persons associates with the purpose of conducting illegal activity.
But that's the prototypical example. Usually the enterprise is, prototypically, I would guess, there are bad actors, plural, not a bad actor, but that doesn't mean that a bad actor doesn't qualify, even though it's not the prototypical example.
So, Your Honor, if you are asking, is it possible to have a legal entity that has a legal purpose, again, I would still come back to Gross. The Florida Supreme Court said you must have a common purpose. Still, the state's never responded or explained what the common purpose between my client and the Jackson County Sheriff's Office is. They have completely different purposes, but you cannot have a legal entity that has a purpose to engage in legal activity and then a single defendant who acts contrary to that purpose, and then have that be a RICO case. And I think you just look to the history of the RICO statute itself. How did we get here? We know that RICO was adopted by Congress in the early 70s, and it was to combat organized crime. And the purpose of RICO is to reduce the power and influence of organized crime and not to punish the lone criminal actor acting as an individual, because punishment of an individual would have no discernible effect on the fight against organized crime or that criminal enterprise that RICO was adopted by Congress and adopted by Florida to go after. In this case, the state had every opportunity, and they did, to charge my client with various crimes. They did. Counts 2 through 67 are all the underlying crimes that the state charged, separate substantive counts that they charged my client with. Those were also all the predicate acts under RICO, but they certainly could charge my client. But this is overreach to apply RICO to this situation where, again, there's no common purpose. That's a requirement under Florida law.
Well, why isn't the common purpose is that the police department has given this officer authority and discretion to act on its behalf? I mean, where the rubber hits the road, the police department, to me, is that officer who has just pulled me over, shown up at my door, what have you. That is the police department. It is that officer acting with the authority, the purpose of the police department to carry out the street duties.
Again, I think in the context of a criminal statute that's criminalizing conduct, when we're talking about common purpose, there's case after case after case that say that common purpose is an illegal purpose. I've cited, again, the federal cases that specifically say that in their definition of what's required for enterprise, but even you can just go to Gross. In Gross, the Florida Supreme Court was looking at other cases around the country, and they cited to the Lim case from the Eighth Circuit. And in Lim, and let me quote from what the Florida Supreme Court said, the defendants perpetrated an insurance fraud scheme involving some 17 arson fires in 5 states. The court found a common purpose where each of the defendants shared with the others the purpose of setting arson fires so as to defraud insurance companies. When we are talking about this common purpose, we are talking about the criminal allegations in the case. We're not just talking about some broad purpose that, the Jackson County Sheriff's Office has a lot of purposes, but the general purpose of the Jackson County Sheriff's Office is to protect the public. It cannot be said that based on the allegations that the state brought against my client, and he was found not guilty regarding 9 of the alleged victims and guilty of 3, but in light of the fact that the jury found my client guilty of 3, it can't be said that the state believes my client's purpose was to protect the public. Clearly, the reason they brought allegations in this case is because they believe my client's purpose was to plant drugs on people in the community. That is not a common purpose with the Jackson County Sheriff's Office, which the state has acknowledged is the only enterprise they're alleging in this case. It's just, and again, it's not just the Gross citing to Lim. Every time we're talking about the common purpose that's required for a criminal enterprise. The Florida Supreme Court also referred to the enterprise in that case as being a criminal enterprise. So what is it that the reason that we're going after this group of people as opposed to an individual is because this criminal enterprise with this common purpose, whether it's under a legal entity such as a police department when you have rogue police officers acting together, or whether it's a particular individual who forms an illegal company and the company along with the individual are frauding the public, whatever it might be, you have to have that meeting of the minds, the association between at least more than one person to create that enterprise. And they must have that common purpose of engaging in illegal conduct. If you expanded the common purpose requirement of Gross and of the federal cases that I've cited to come up with any...
Those cases aren't precedential on... I mean,
they're not. They're again...
We're interpreting a statute, and there are cases...
Gross is which is why I filed my supplemental authority yesterday. Gross is cited in my initial brief in the argument of Mr. Davis to trial court. The state cited the Gross, but Gross is obviously the case that's binding on Florida, and Gross specifically defines what's required for an enterprise. And again, despite it not being in the explicit language of the statute, despite it not even being in an instruction, and those aren't the challenges that we have in this case. I'm not challenging the constitutionality of the statute. I'm not challenging whether or not the jury instruction was correct, but we are challenging that the evidence was insufficient to establish that there was a criminal enterprise such that my client could be convicted of RICO. The Florida Supreme Court has specifically said, and again, it's still good law, it's a 2000 case, that in order to establish that there's an enterprise, the state must prove that there's a common purpose of engaging in a course of conduct. There's simply no common purpose in this case.
Thank you, Mr. Efferman. You're down to 1:43. I'll give you an additional minute on rebuttal.
Thank you. Let me just quickly say, and I won't spend a lot of time on this, I think it's adequately addressed in the briefs. Obviously, I'm hopeful you'll agree with my argument that RICO was not established in this case. I think the trial court really struggled with that. If if the judge erred by denying the JOA for the RICO count, the remedy should be a new trial. And I've cited to the Turquette case from the First Circuit because the other alleged victims in this case, the alleged victims were only brought together in one information and pursued in one trial because of that RICO count. If you take away the RICO count, this would have been 12 separate cases. The state argues that this wasn't preserved. My response to that is, how could Mr. Davis possibly preserve this prior to the judge granting the JOA? A precondition to him arguing that the other counts should be severed and there should be a mistrial is the judge agreeing that RICO was improper. The judge never made that finding. Alternatively, at the very least, my client is entitled to be resentenced. As I've argued in the briefs, the score sheet is substantially impacted by removing the RICO charge from the score sheet. I believe it's 74 points. Let me tell you the exact numbers. It's 74 points on the score sheet, and the minimum on the score sheet was 81 months with the RICO charge. It would go down, which is 6.75 years, it would go down to 25 months if the RICO count is removed, and Florida is clear that a defendant is entitled to be sentenced with a correct score sheet. So I would ask you to reverse for a new trial, or alternatively, at the very least, reverse for resentencing. Thank you.
Good morning.
My name is Darren Shippey. I represent the state of Florida in this matter. Let me tell you what you need to know first of all, because it can get a little bit foggy if you don't pay attention to what we're actually talking about, which is, what do you have to have for a RICO charge? There are three things. The statute requires if you can have someone held criminally liable. Number one, you got to have a person. Number two, you got to have an enterprise. And number three, you got to have a pattern of racketeering activity. Don't lose sight of that. Person, enterprise, pattern of racketeering activity. So here's what's unlawful under the statute, and this is why I'll take issue with what Mr. Ufferman said. It's unlawful for any person. It doesn't say persons. It doesn't say you have to have a group of people. It doesn't say we got to get together and have more than one. Any person who is employed by or associated with any enterprise to conduct or participate directly or indirectly in the enterprise through a pattern of racketeering. That's it. It's not complicated. We have that in this case. We have a person who's employed by or associated with the Jackson County Sheriff's Office who conducted or participated directly or indirectly in the enterprise, and he did that through a pattern of racketeering, which is what he was convicted of on I think it was 18 counts of the underlying charges. The jury instructions recognize that. They don't talk about a common purpose. They don't talk about having to have multiple people. You have to prove three things. Number one, Zachary Wester, i.e. the person, was employed by or associated with an enterprise. Number two, that he conducted or participated in, directly or indirectly, in such enterprise by engaging in at least two of the following incidents, and they list what the charges were.
So your position is that the enterprise doesn't need to be illicit? Or
Absolutely
have a
not.
bad
Statute
purpose?
says exactly the opposite.
Now, are the cases all over the place?
No, I don't agree with that. Now, I'm going to explain why I think there may be a misunderstanding of what these cases hold. But let me finish with the jury instructions that he engaged in at least two of those acts of racketeering. The enterprise was defined for the jury, which was it means any individual, sole proprietorship, partnership, corporation, business trust, union chartered under the laws of the state, or other legal entity. Here's what you need to understand that makes this really easy, in addition to what makes a racketeering charge. The statute contemplates enterprise as being one of two things. Number one, it's a legal entity. Number two, essentially, it's a group of individuals. A legal entity or a group of individuals.
Well, I mean, is it that simple? I mean, if you look at gross, our Supreme Court's adopted the 11th Circuit more broader view, citing Cagnina. You look at Cagnina, definition of enterprise, it specifically, as Mr. Ufferson mentioned, defines it as a group of persons associated together for a common purpose of engaging. So how do you mesh those two?
Once again,
Cagnina
they are
and
dealing
Gross.
with a fact pattern that was nothing more than a group of individuals. If you read the statute, you're going to find that there is a definition.
Oh, I've
for-
read the statute, but,
Okay.
but how do we how do we mesh that rub against what we have in Gross, adopting Cagney definition versus the argument you're presenting?
And I'll say it again, it was a group of individuals was the fact pattern that those courts were dealing with. They weren't dealing with the fact pattern that we have here, which is a governmental entity. That's why, as Judge Osterhaus brought up, in Ruiz, the defense stipulated, as they properly should, that the police department was an enterprise. In the Welch case, which was even an older case, out of Texas, the enterprise, was I think it was the Gregg County, Texas Sheriff's Office. A fact pattern that involves where we're trying to hold somebody liable under RICO with multiple people probably needs to have some sort of common purpose. Otherwise, everybody's randomly doing whatever. That's not what we have. And the statute specifically contemplates there are two types of the way we're going to look at enterprises in Florida, which is one is a legal entity, which is specifically defines a governmental body, licit or illicit, and a group of individuals where you probably have to have this common purpose. Otherwise, if Judge Osterhaus is out committing some crime, and you're out committing some crime over here, and Judge Lewis is out committing some crime somewhere else, I don't have an ability to bring the three of you in together as a RICO action. And that's what the statute
So you're arguing you could bring us each individually in for a
No,
RICO
I am
action?
not. No, I am not, because you're not using an enterprise. You got to have a person, you got to have an enterprise, and you got to have a pattern of racketeering.
Say our illicit behavior had something to do with the court.
Pardon me?
Say our alleged illicit behavior had something to do with our jobs at the court.
Okay, if you're using the First District Court of Appeals, you individually, to commit a pattern of racketeering, then yes, you've committed a RICO. You're going to be subject to the RICO statute. I don't have to have more than one person. The statute doesn't say I have to have more than one person. It says any person who does that. It doesn't say we have to have a multiple or a group of people. So the fact pattern that you're concerned with and the cases that you're focused on are cases that deal only with the group of individuals where there's no defined entity. We have a defined enterprise in this case, a defined entity. We have the Jackson County Sheriff's Office. Those cases have nothing to do with this case, nothing whatsoever. The statute controls and defines, once again, person, enterprise, racketeering activity. And as I said, the Jackson County Sheriff's Office meets the definition of an enterprise in this case, as we defined it in the statute, because it didn't specifically. And by the way, although the courts seem to say that the Florida RICO statute is patterned after the federal model, the enterprise definition is not. Our definition is much broader, much more specific to include licit or illicit and governmental specifically. So it contemplates a situation exactly what we're talking about. Any person, not any persons who directly or indirectly participate in an enterprise through a pattern of racketeering activity is on the hook for a RICO charge.
What's the best case that deals with a single person and a who's employed or is employed with a licit, illegal operation, and yet is rightly charged, convicted of racketeering?
What's the best case?
Yes.
I picked out the 5 best I could find and put them in my brief. I think if you want something that's related to law enforcement, then you look at Welch and you look at Ruiz. Once again, in Ruiz, the defense stipulated the enterprise was the police department. The issue in that case is whether it was a pattern of racketeering, but they specifically acknowledged that the police department was a enterprise, as the enterprise was found to be in the Welch case, which was out of Texas, where the sheriff was doing whatever he was doing along with some cohorts. So I think The best cases I can give you are the ones that I put in there, in part because they deal with an enterprise that's a legal entity. It's not dealing with a group of individuals that we're trying to combine together to create
So
an
Mr.
enterprise.
Ufferman says, well, really, the enterprise there are the bad guys. It's not really
He's
a
wrong.
legal entity.
He's wrong.
But-
Flat out, he's wrong. That would be completely contrary to what the statute says. He's reading something into the statute that doesn't exist, that we've got to have this group of bad actors within the enterprise, and we've got to have more than one. That's not what the statute says. It can be a illicit organization, be governmental. It's only got to be one. The jury's instructed. Any person who does this. That's what the statute says. Any person who does it. So if
So
you
the
give a
opinion
strict...
in this case will be the first case that really deals with a single person
This-
and a legal enterprise, because the other ones all deal with multiple bad people and an
And
enterprise.
that's why I think both, one thing that Mr. Ufferman and I agree about, and I think I actually put it in the brief, was it's a unique fact pattern, and I don't find a case that actually answers this specific fact pattern. But the fact pattern doesn't change what the law is, doesn't change how we apply the law to the facts, and when we apply the law as it's written in the statute to the facts, it's very simple. I got a person, I got an enterprise, I got a pattern of racketeering activity conducted through this enterprise by this person.
So your
Gains-
position is clear that the enterprise need not exist for the purpose of conducting illegal activity.
Does not have to, and there's case law out there that specifically says, originally RICO was designed for organized crime. Cases that have come out since then said, hey, we don't have to look for some sort of corrupt or illegal organization. If you meet the definition of the statute, then you're still liable under the criminal liability of RICO. So you don't have to have this corrupt corporation or corrupt entity or corrupt enterprise, whatever you want to call it. Once again, that would be adding words into the statute. And if you find those words and you look at the fact pattern of the cases, you're going to find that it talks about a group of individuals. That's what it talks about, because we're trying to hook a group of you together, which is why I gave you the example of the three of you going out and doing your own individual things. If I'm going to connect you together, I've got to have a common purpose so that I can bring you under the statute that talks about a group of individuals and charge each of you individually. But we don't have that here. We have the enterprise. There's absolutely no doubt what we have in this case is an enterprise, which is the Jackson County Sheriff's Office. So we have the three components. And the common purpose, like I say, would have more application to trying to create an enterprise, literally create an enterprise out of a group of individuals, but not when you already have an enterprise in place.
Let me ask you this.
Yes.
Concentrating on the plain language of the statute, which is where we always start, how do you define, or what do you think the purpose of the phrase directly or indirectly? Now, more specifically, indirectly. So it says any enterprise to conduct or participate directly or indirectly. What's the significance of indirectly?
Well, I don't know exactly what they meant, but I can tell you that Mr. Wester would not have been able to do what he did if he was not a sheriff's deputy with a badge, with a uniform, with a patrol car, pulling people over and doing what he did, which was planting drugs on them.
I mean, do you
He's-
think that the
he's
use of
participating-
indirectly supports your argument that, you could use an enterprise for your personal end without them knowing what's going on? So the enterprise, the other individuals in the enterprise could involuntarily participate, but the sort of mens rea certainly is in the person or committer.
Yeah, we're focused on Mr. Wester in this case, who clearly is participating in the operation of the Jackson County Sheriff's Office. And the cases that I've cited say the benefit doesn't have to run to the sheriff's office. As a matter of fact, the Welch case, the one out of Texas, that was the argument the sheriff made. He said, well, the enterprise, i.e. the sheriff's office, wasn't getting the benefit of what was happening. I was personally. I said, we don't care. You're still
So
on
do you
the hook.
think that directly versus indirectly, that in the course of a day, Mr. Wester did 100 things, 95 of them might have been normal, regular, appropriate police actions, but 5 of them were illegal and lawful, and those may be indirectly related to?
Yes. In this case, he was convicted of 18 of the underlying predicate acts, 3 individuals, 6 different charges. So 3 times 6 is 18, add 1, the RICO count gets to 19. So yes, he was participating as it relates to those people. We would say that he was participating related to the other people as well. He was found not guilty of those, but he was using every resource that he had available to him as a person of the Jackson County Sheriff's Office. So he was participating, in this instance, directly in the organization through a pattern of racketeering by doing what he was doing.
Counsel, neither party has cited a case that's directly on point with the facts of this case. Would the facts of this case be a case of first impression for
Yes.
this court?
Yeah. I wrote that in the brief. I don't think Mr. Ufferman would agree that it's a very unique fact pattern. What we disagree on is how we apply the law to that fact pattern. And the state's position is you got to have a person, enterprise, and racketeering activity. He says you got to have this common purpose, which I don't believe applies in this case. Let me wrap up really quick because my time's running out, to the extent you would even consider it. But the misjoinder, the one case that Mr. Ufferman cites, there was actually a motion to sever in that case. I think it's Turquette. So that case had a preserved issue on the issue of misjoinder. There is no preserved claim in this instance. Fundamental error was not argued, nor did it constitute fundamental error. As a new sentencing with respect to the RICO Act, I don't disagree with how the score sheet would change, but you have to make sure you understand what the sentencing pattern in this case was. The judge was pretty smart about that. He gave him 5 years on the RICO count over here. Over here, he ran all of the other cases, counts, the 18 of them, consecutive to each other, with the first count being, I think it was count 7, concurrent. So if the RICO count was to go out, it would absolutely have no impact on this, because he'd made a decision, and he announced it on the record. He was trying to get to I think it was like a 12-year sentence. When he did all of these sentences over here consecutive, he got to where he wanted to be, which was 12, 13 years.
How many counts was Mr. Wester charged with?
Originally 67.
And how many counts was he convicted of?
19. 1 RICO count, 18 of the predicate offenses involving 3 victims.
Thank you, Mr. Shippey.
Okay, thank you very much.
May it please the court. I'm hoping to make 2 points. The first one involves gross and common purpose. The Florida Supreme Court didn't limit its holding to this type of enterprise or that type of enterprise. The conclusion of the case specifically says, conclusion, in order to prove RICO's enterprise element, the state must prove the following 2 elements. It goes on to say, an ongoing organization, formal or informal, with a common purpose of engaging in a course of conduct. That is what's required under Florida law.
And not just a truism for that case, that particular fact pattern. The truism is they needed to prove that for there to be an enterprise in that case.
Correct, but that the holding of gross is an enterprise in Florida requires the common purpose. So I understand why Mr. Shippey is trying to say that gross shouldn't apply, other than this is, again, a Florida Supreme Court case that's not limited to a particular set of facts or a particular type of enterprise. But it's because Mr. Shippey, and I understand, to his credit, and the same thing as Mr. Williams below, now Judge Williams, that they can't establish a common purpose. When asked several times, the state in no way alleges that there's a common purpose between my client and what they're saying is the enterprise in this case. And that is an essential element of an enterprise to make this RICO as opposed to the run-of-the-mill regular crimes for which he was charged 66 times in this case. So we do not have the common purpose requirement under gross, and that's reason number 1 why this court should reverse. But number 2, I think it's telling that there's not RICO charges have been brought throughout the country since 1970. We have hundreds, if not thousands, of cases where RICO charges are in the news right now. There's not a single RICO case that involves a legal entity and a single actor where they don't share a common purpose? Not one?
Well, look.
But well, and I know you will, but up until now, the parties agree that we can't find one. The trial judge couldn't find one, and this case should not be the first one where this court affirms under that fact pattern. So I'm asking this court to reverse. Thank you.
Very good. That ends our session for today. Thank you.
All rise.